Welcome back, everyone. I hope you enjoyed your lunch. I think we're ready now to start the second half of our day. Our next presentation is from Ms. Dawkins and Mr. Meadows, attorneys from Steptoe and Johnson who practice in West Virginia.
Thank you. Conflicts between mineral owners and surface owners and producers of oil and gas have been prevalent over the past century because the drilling of oil and natural gas necessarily entails some type of damage to the surface. In situations where you have the mineral estate severed from the surface estate, you will find that the mineral owner often wants very broad rights to use the surface. They want to use whatever part of the surface that they need to use for whatever purpose they think they need to use it for. And the surface owner, on the other hand, they want to limit the use both in the span of the use, the amount of surface that's being used, and the time period in which it's going to be used. So today we're going to talk about the legal implications that are surrounding that historical conflict that's been around, again, as I said, for over the last century. And we're going to compare and contrast the rights between mineral owners and surface owners. We're going to discuss express rights of a mineral owner or producer to enter the surface of a certain piece of property to drill, as compared with the implied rights that are, as stated, implied by law. We're going to look at the different approaches that the courts have taken in analyzing these various issues, including the multidimensional approach and the unidimensional approach, and we'll explain that in a little bit. We're going to go over some horizontal drilling specific issues, and John's going to talk to you about some specific statutes that are applicable to the practice of law here in North Dakota and elsewhere. And we're going to talk about litigation versus legislation, and again, including a discussion of some specific statutes that can help in these gray areas. This simple illustration shows us the two often competing interests when it comes to the drilling of oil and gas. Somewhere back in the chain of title, the mineral rights were severed from the surface estate, and that could have happened either the surface owner at some point in time conveyed the mineral rights to someone else, or most often what we see is that the mineral owner conveys the surface and then that person specifically reserves the mineral rights to themselves. So what's the issue? Well, I think it's pretty clear. I own the mineral rights under this tract of land and your surface is covering it. I need to get to it to exploit my natural resources, and I can't do that because your surface is covering my land or my mineral rights. The owner of the minerals cannot drill the resources without some type of easement on the surface estate. And there are two types of easements. The first type is called an express easement, and the second type of easement is called an implied easement. Express easements are easements that are actually created in some type of a legal document, such as a lease or a deed. And generally, those set forth the scope of the mineral owner or the oil and gas producer's right to use the surface when drilling or extracting those natural resources. The earliest cases dealing with the respective rights of surface owners and mineral owners have dealt specifically with provisions attempting to set forth express easements in lease documents. And that's exactly what we've got here. This is a sample of a lease agreement that was dated back in 1894. This is an express easement found in a lease. It says that the lessors have the hereby demise and grant unto lessees all the oil and gas in and under the following described tract of land, and also the said tract of land for the purpose and with the exclusive right of operating thereon for said oil and gas, together with the right-of-way, right to lay pipes over and to use the water from said land, and also the right to remove at any time all property placed thereon by the lessees. And I know that a lot of you do land work, and this is probably typical of the type of lease that you would find back during this time period. Now, in modern days, you will often find that the lessee is trying to make as broad of an express easement as possible in order to use most of, if not all of, the surface. And in this particular case, we've got an oil and gas lessee that that's able to enter the property for the purpose of exploring, prospecting, drilling, and mining for and producing oil and gas and all other hydrocarbons, laying pipelines, building roads, tanks, power stations, telephone lines, and other structures thereon to produce, save, take care of, treat, transport, and own said products, and housing its employees, and without additional consideration does hereby authorize lessee to enter upon the land covered hereby to accomplish said purposes. So this, this isn't, not going to say that this is actually something that would be typical on a lease, but it's funny to what extremes the lessees will go to try to get to use as much of the surface as possible. Now, what about rights to use the surface that aren't expressly set forth in some type of express easement in a deed or lease? Well, if you don't have an express right to enter onto property, then any right that you have to enter onto the surface of that property and use that property are necessarily implied. It's important to keep in mind that in most jurisdictions, when you have issues where the surface estate has been severed from the mineral estate, the mineral estate is considered the dominant estate. A lot of people don't realize that, and the surface estate is considered the servient estate. And as you read through the case law discussing these easements, it's interesting because even in cases where you have express easements that the courts are looking at, they still apply the doctrine that's applicable to implied easements. The seminal case on the issue of implied easements is Charda Block Coal Company versus Mellon, and that's a Pennsylvania Supreme Court case that was decided back in 1893. And in that case, it involved a lease that contained express language giving a coal operator specific rights with respect to use of the surface. Said you can come on the land, go across the land, extract the coal, basically do whatever you want to do. And the court held that the mineral owners would have the right, even without any express easement, to go upon the surface to extract the minerals in any manner necessary, now that's an important word, to operate his estate. The right is to be exercised with due regard, another important term in this, to the owner of the surface, and its exercise will be restrained within the proper limits by the court. So without knowing this, the Pennsylvania Supreme Court in this case basically set out the principles that are going to be applicable for the next 100 years to that. And again, the words are necessary and due regard. So hence we have born the beginning of the unidimensional approach and the multidimensional approach to implied easements. Now the unidimensional approach, if you've ever looked at case law in this area, you won't see the word unidimensional very much, but you will see the words reasonable use or reasonably necessary. And what that does, it focuses, states that follow this reasonable use approach, they focus really on the mineral owner. What does the mineral need to do? What is it necessary for them? What use of the surface is necessary for the mineral owner in order for that person to be able to extract the minerals? Now, the multidimensional approach, that term due regard, that's known as the reasonable accommodation doctrine. And states that follow that approach, they don't just look at what the mineral owner needs with respect to the surface, but they also look at the surface owner. The surface owner has rights. If there are less intrusive means that the mineral owner or operator can use to get to his minerals, then the court's going to make them do that. So you've got these two different approaches, and you have different states following different approaches. Like in West Virginia is a reasonable use state, and that's more favorable to the mineral owner. They focus on the mineral owner. It really in all essence, doesn't matter as long as it's necessary how much disturbance to the surface estate that you get. North Dakota in 1979 became the 4th state to embrace the reasonable accommodation approach. And that case was Hunt Oil Company versus Kerbau. Before this case in 1979, North Dakota was a reasonable use state, not a reasonable accommodation state. And in Hunt Oil, the court defined the accommodation doctrine as it applies in North Dakota. And the court said it's not a balancing test, weighing the harm or inconvenience to the parties. Rather, the court is to test the availability of alternative non-conflicting uses of the two types of owners. Inconvenience to the surface owner is not the controlling element where no reasonable alternatives are available to the mineral owner or lessee. The surface owner must show that under the circumstances, the use of the surface as proposed is not reasonably necessary. So we have reasonable use states and reasonable accommodation states. However, it's interesting when you look through this case law over the past 100 years, I would say that 90% of the case law, the courts find in favor of the mineral owner on these issues. And the only time that I've seen where they don't find in favor of the mineral owner on these issues is where the use was really not necessary. They were doing something on the property that wasn't necessary for the extraction of the minerals, and they were in somehow negligent. Now, this is an important concept to know, and not a lot of people know this, is the fact that under the common law, and what I'm talking about is where you're in a state where there is no statute that is specifically addressing surface owner compensation or damage to surface, if you don't have one of those statutes, then the mineral owner is not required to compensate the surface owner at all for use of the surface in drilling unless that drilling was negligent, unless they in some way were negligent on the property. There's no requirement under the common law to compensate because they have the legal right to be on there. That's their easement. They have the legal right to use the property to extract minerals, even if they have to cut down trees. If it's necessary, the surface owner is not entitled to compensation under that. It's only when you get these surface owner compensation statutes that have been enacted by various legislatures that they're entitled to actually get compensation. So here we've gone over so far this historical analysis of this ongoing conflict between surface owners and mineral owners, and this has been used consistently throughout the analysis in dealing with vertical wells. Now, notice I said vertical wells. That's what this law has been applied to. So, to complicate matters, we move from the 1800s to today, and this is what we've got. Now, you can imagine what a surface owner is going to say when a mineral owner or an oil and gas producer comes to their property and says, hey, I'm going to put a horizontal well pad on your property. I mean, obviously, the surface area taken up is a lot bigger. You now, instead of just the typical size for a vertical well site, you now are encompassing 4 to 5 acres with the pit. It's just a whole lot of different complicated issues. And believe me, surface owners are jumping up and down over this. I would say that 80% of my practice right now is dealing with surface owners. I represent the oil and gas companies, so I'm not on the surface owner side. So 80% of my cases now are dealing with surface owners who simply don't want these things on their property. And it's created a lot of expense for the oil and gas companies, and it's created a lot of turmoil within the court systems. So when you're dealing with horizontal drilling, that necessitates the use of the surface of one parcel in connection with operations on other properties now. We're not just limited now where you've got a vertical well on one piece of property and you're drilling straight down and you're mining the minerals directly under that surface. With horizontal drilling, now we've got the capability of going out sideways to adjacent properties and beyond the boundaries of the surface estate. So that complicates things. Surface owners try to argue, or they do argue, that the surface use is limited to drilling from the surface of a particular parcel to the minerals underlying that particular parcel. And they are also arguing that horizontal well pads are an overburdenment to the surface estate because of the sheer size. And these arguments, in West Virginia at least, there's a surface owners rights organization, and it's led by a couple of different attorneys in the West Virginia area. And what they are doing, they're kind of championing this cause for surface owners. And they're actually, if you go on their website, they're telling people you have the right to refuse a horizontal well pad on your property. And the analysis that they're using is they're saying that you have to go back to the deed in which your surface was severed from the minerals of the property. And when you look at that deed constitutes a contract. And if that deed doesn't specifically set out that you can use the surface of my surface of my property to drill from adjacent properties or neighboring properties, then that's a contract, and you simply can't do that. Another argument that they're making based on this deed, on these severance deeds, they're saying that you have got to look at the technology that was in place at the time that the minerals were severed from the surface, and you have to construe that deed or contract in light of those technologies. So in other words, in West Virginia at least, most of the minerals were severed from the surfaces back in the late 1800s, early 1900s. You have to look at what was in place at that time, and that's how the contract or the deed has to be construed. So therefore, you know, these huge well sites were not envisioned at the time, so therefore you can't put that on my property. And that's basically the arguments that they're making. Well, I'll address that second argument first about the size of the well pad and the technology that was in place at the time of the severance. And let's say that the severance was back in the late 1800s, early 1900s. What was considered reasonable use of the surface at that time? Well, we've been able to find some pictures. And some of these pictures were taken about that time period, early 1900s. And as you can see, they show drilling locations. Plaintiffs' attorneys who represent surface owners hate it when we bring these things to court because as soon they know what's going to happen. And it gets worse as we continue. This is what it looked like. So I think it's pretty hard for anybody to make the argument that this was reasonable use of the surface when at the time that the minerals were severed from the surface estate, but yet your horizontal well pad was not. So we've been pretty successful on that issue. With respect to the other issue, that because of the deed, you are only able to drill directly from the minerals directly underlying this surface, the surface of my estate. It's true that it is generally recognized that the implied easement, and this, again, this is if you don't have a surface use agreement, okay? This is trying to use the implied easement, like we talked about before, to obtain your rights to drill. It's generally recognized that the implied easement of surface use does not extend to support activities benefiting off-lease properties. However, the rule changes, and it should change, when either voluntary or forced pooling or unitization occurs. So, when there is pooling or unitization, you should have the same implied easement of surface use rights when it meets that reasonable use or reasonable accommodation doctrine test. And again, it depends on what state you're on with this. But there's a lot of litigation on this issue. I have encountered this issue several times. In West Virginia, there's nothing directly on point, but we have a case out of the Northern District of West Virginia that was decided back in 1983, I believe it was. And it involved this issue, but not necessarily the exact issue. And we rely on that. And we were sued, one of my clients was sued in state court on this very issue. I recognized diversity jurisdiction, and I immediately removed it to federal court. So we were in federal court where I knew that the judge was going to apply the reasoning of this 1983 case that came out of that district. And what that case involved, it involved a pooled or unitized area with leases. And the oil and gas operator wanted to, they were putting the well site on one of the surface tracks within the pooled area, and they wanted to drive across one of the other parcels in order to get to that. But they were all within the pooled area. And the court held in favor of the oil and gas owner, saying you can use the surface of any parcel within that pooled area in order to benefit the entire lease or the entire issue. So that worked out really well for us. When we removed it to federal court, they ended up settling the case pretty quickly because they don't want the issue decided there. But it is pending in several other courts in West Virginia, and there's been mixed results in other states. I think Oklahoma and Texas have some favorable decisions on this issue. And again, we're talking about not going off lease, but we're talking about using the surface of one tract within your pooled area to benefit the entire tract. There was a case, though, in Ohio, in a lower court in Ohio, where the court held just the opposite. He said, no, you cannot drill from one parcel to benefit the other parcels. But that right now is on appeal. So there's nothing that's really precedential that comes out of that. But the position on this issue is very, very strong in favor of the oil and gas operator when you are in a state that has a forced pooling statute and a corresponding surface owner's compensation statute. Now, in West Virginia, we do not have a forced pooling statute for deep wells, but we do have a surface owner compensation statute. And it makes sense that you should be permitted to do that specifically in those states, because otherwise, surface owner use compensation statutes are enacted to compensate surface owners for unanticipated damages based on drilling such as these new technologies. That's the whole purpose. And again, I go back to the statement earlier that I said that under the common law, you really don't have any legal requirement to pay a surface owner for damages because you're doing what you have either the express right or the implied right to do on that surface. Now that we're kind of expanding things a bit, it makes sense that courts or that legislatures have adopted these statutes that do provide surface owners with compensation for the additional burdens that are on their property. So I'm going to turn it over to John Meadows right now. He's going to go into a little bit more detail on the use of these type of statutes and other issues related to horizontal drilling.